All right, good evening. I appreciate you guys coming out. I promise I won't be boring you to death with slides. It mostly keeps me honest and I manage to keep my notes going. My name is Jim Nettles. I write fiction as an author under James McDonald, as well as a couple of other names. I write in a number of genres. I write science fiction, fantasy, horror, urban fantasy, a little bit of contemporary, a few other things. I also write a lot of nonfiction. I work in the spaces of AI, technology, business intelligence, ethos, and work in a lot of those different spaces. I am not an attorney. I have played one occasionally on TV. However, the property and the information we're going to go through in terms of intellectual property is stuff that I've developed in my career in technology. I've worked with a lot of startups. I've worked with a lot of IP from software, hardware, manufacturing, processes. And this material was actually done and developed in coordination with a number of different attorneys I've worked with and consulted with over the years. So I appreciate you guys coming out. And so what we're going to be looking at and talking about, so does everybody know what we're talking about when we start talking about intellectual property? Everybody know? Excellent. Intellectual property is what we're talking about with anything that comes from the mind. It's a legal term of IP. And so what we're looking at talking about with this is that intellectual property is really anything that you come up with and create from your mind. In other words, it's anything that is an idea. And a lot of the time, and what we're going to be talking about here are the ways that we secure intellectual property. What's it important for? Why do we care? Because intellectual property is an asset. It's something that we build, we create, and in a lot of ways, it is the driver for everything that we do as a society. And intellectual property security comes in a lot of things that we're all pretty familiar with. Copyrights. So we as authors really care about our copyrights. We care about our trademarks. We care about our patents. And if you're in software, if you're in hardware, if you're in a lot of the physical materials, you care about patents. And then last but not least, something that we deal with a lot more than we used to, which is something called a design. So if you are in archery or artistry, if you are doing a lot of things, especially in England, in parts of the EU, the designs are a very specific kind of legal property. And so if you're dealing with cover designers, people who are doing artwork and stuff for you, you're also going to run into designs. So while that's not a US concept, it is one that we do frequently now deal with because of the way that international law works. So let's talk about each of these and what they cover. So copyrights, so we as creators, as authors, copyrights cover intellectual property that is written material fundamentally, or it is publishing material. It is, whether it's written, whether that's film, whether it's music, anything along those lines that is not necessarily a physical property in those mediums is typically going to be covered by copyright. And we're going to talk about a lot here about copyrights because that's one of the most common and most convoluted forms of IP that we deal with a lot. Number two, patents. Patents really are geared towards inventions and innovations. So what we mean by that, so if you have a patent and you've created the next new, great strainer or whatnot for pasta, there are other pasta strainers that are out there, but your patent covers if you've come, up with a new great mousetrap or whatever else may be.
What about?
No, please go. And this is 100%
what about
right.
the idea of, let's take an iPod.
Mm-hmm.
Apple created it. They obviously have, but if you take and put a different logo, or you change the physical shape of it, is it a new product, or is it just, does Apple still have the rights to it because you didn't really change it, you just repackaged, you made it look different?
That's an excellent question. And let's take your iPod, for example. Let's take something easy, looking at an iPod. That is not a singular patent. That is made up of hundreds and thousands and honestly tens of thousands of patents go into the iPod. So that was not the first MP3 player. In fact, there were a number of them that came as predecessors to that. What a patent encompasses is not only the technology of the iPod, but everything that went into it. You know, so if you remember the good old-fashioned iPods with the little round spinner on them.
Yeah, I remember that.
There were a lot of patents designated just to that idea of using that round control. So what we're talking about here is not necessarily the invention of an MP3 player. We're talking about the innovations that then create the iPod. And so, for example, one of the fun things that has just come up with a lot of legal interpretation, everybody familiar with the little buttons from Amazon, the quick order buttons from Amazon? That is not an invention of Amazon's, even though they do hold a lot of patents around them. That quick order button that goes by, it was an innovation, used a lot of different off-the-shelf technologies, but they created it and used it in a different way. So all of those patents became an innovation, but there were a number of suits and questions around whether or not they did that right.
So the idea is, if they didn't create the patent, one of the patents that is used by them, they still have to secure the rights to be able to use that patent.
That is correct.
Because somebody else owns.
Somebody owned the idea. But here's what always gets interesting, is are you getting a patent based on something that is an innovation? Are you using it in a new and different way? Because even though somebody may have a patent, and I'll tell you where the most frequent area about this is in drugs. So if you have a patent on a drug and it's patented for certain very specific uses and somebody finds out another use for that, then usually what will happen is they will come and buy and license that additional use. But it gets really deep into minutia when you're dealing with those. So trademarks, since we're going down that path, trademarks are words, phrases, symbols, and designs as to how they're used very specifically. So one of the things that we're going to talk about is going to be the big rat from Disney. They are going to be the band hammer that comes down on a lot of intellectual property. And now that they acquired things like Marvel and a lot of these other properties, Star Wars, there's a lot of things that gets done and shared and used in fandom, and Disney isn't used to being very friendly about it. So that's going to be a really interesting thing. But trademarks are things like the Coca-Cola label. And there are a multitude of ways that trademarks show up. There's registered trademarks, and there's a number of ways and shapes that they show up. And then last, like I say, we'll talk about it. Designs are UK specific intellectual property around images. So we'll dive into all this and we'll have a lot of fun talking about the specifics of the different cases. Copyrights are one of the most convoluted pieces of case law. We'll talk about why this happens. If you have a piece of work today, one of the new things that was passed was, as soon as you create a work, there's an automatic copyright assigned to it. So in other words, when you see blog posts or a lot of these things, you no longer have to file a registration to get a copyright. As soon as it's established and done, you have a copyright. You can't defend it without filing for your copyright, but you get an automatic copyright for, you don't have to publish it anymore. It's a matter of as soon as it's written, you have a copyright to that. So for example, one of the things that I've talked about a lot is, people say, I came and I've got this brilliant idea, I'm gonna give you the idea, you write the book and we'll split it. And I'll look at them and go, no. And in fact, I can take your idea and go do anything I want to with it, because what is protected by copyright is not the idea, it's the execution of it. And the question becomes, at what point does something go from being an idea to how you execute on the idea? That's why you will see people in Hollywood, that's why you will have publishers come and say, somebody comes around the table, I've got the greatest idea. You will hear them go and say, great, go write it. Don't tell me, I don't want to know anything about it, because I don't want to potentially get into something that if something creeps into one of my own stories, that there's a legal fight about that. But copyrights today are good for the life of the author plus 70 years. Except, and I have to follow the notes because it still changes all the time. And there's multiple ways. There is, a copyright is granted for the life of the author plus 70 years, or if it was done under a pseudonym or for hire, then it's from 95 years at the date of publication or 120 years from the date of creation. And so copyrights apply to written works, music, software, image creation, a whole plethora of things, but the copyrights are generated automatically, but defended. In other words, if there's a challenge to your copyright, then you have to register it with the U.S. Patent Office, Patent and Copyright Office, or with the Patent and Copyright Office of your given country. Most countries will recognize a U.S. patent. There are a couple of very specific ones, such as China, that will not recognize your registration of intellectual property, which is why you see so many pirated videos, books, and we'll talk about this as we get a little bit deeper. You can have the expectation that your work is going to be stolen at some point. And we're going to talk about how you defend against that and what you have to do. Patents are granted for 14 to 20 years, depending on a number of parameters, and can be renewed usually at one time. Trademarks don't expire as long as they stay in effect and as long as you keep paying the registration fee. And then designs, like I say, do get kind of interesting. So, I've created something. What are my rights? Well, if I've created something, that belongs to me, right? The answer is not necessarily. So, if I have created something, I own it outright, it's mine, except if I did it for hire, if I was paid to do it. They're mine unless I did that working for another organization and entity, which is a little bit different than for hire. And one of the things that you'll find is a lot of the time when you have an employment contract, they will say things along the lines of anything that you create as a part of your job, that intellectual property belongs to us. And as an author and as a creator of some of the things, when I go through and I work with clients and we have conversations about creation of intellectual property, we have to have very specific discussions about what belongs to them versus what I retain. You have one, assuming that you hold the rights to that, and in most cases you will, or do, or you will have some rights to it, then you have a right to sell, license, or issue rights for people to use that. And that's usually where you as a creator profit, are because you're going to license rights to your book to be published by a publisher. You're going to issue and license rights to a magazine to issue your articles, your licenses. If you own intellectual property that is patented, you have the right to sell and license it. And there are very different distinctions between sold and licensed. Because in essence, many forms of intellectual property you can't truly fully sell, but you can license someone to 100% of the rights of it for the term of your license and ownership.
Which means you can get it back.
Which means you can have rights of reversion. So for example, one of the things that's very common in movie, TV, and film is that you will sell your rights of a book or something to be made into a movie or a TV show, for example, for a year. But you're not going to license that indefinitely because you typically will have rights of reversion if that movie or film or TV or whatever is not created within a certain time frame. So a lot of times those rights are licensed for 1 year. Or for example, if I have a book, the old rights of reversion typically were if you are out of print for 12 months, 24 months, 36 months, something like that, those rights would revert. Now that's a lot more complex with ebooks, because technically you can have something that never goes out of print because the ebook is still available for sale. So what you'll find is that unless you hit certain sales targets every 12 months or certain things along those lines, the publisher will then or you as the author can request your rights back. Or you as an author and a creator always have the right to request your rights back from your publisher, but they also have the right to say you have to buy them back. And the reason for that is, if you're going through a traditional publisher, they have invested and paid for, editing, covers, You know, there's a lot of money that gets invested into a book, even without talking about marketing, to make it a viable product. So all of that has to be done. So they have to recoup that investment one way or the other. Now, if you have somebody that has bought the rights to the book, they've edited it, they've done everything else, and they haven't ever published it or released it, usually you have some rights of revision. Darren Kennedy just had to go through the process of getting his rights back for some of his books because of some of the challenges the publisher was having. And so he reacquired those rights. A new publisher, Falstaff, has picked those up and will now be republishing those books. But they're also re-editing it. There's new covers. So here's one of the interesting things. If you have a book and the cover, the rights to that cover don't go along with the rest of the manuscript of the book.
You didn't do it.
Didn't do it.
The publisher.
The publisher owns those images. If I publish something myself and I get the rights to that cover, I have the rights of that cover to be able to use it for the book. I have the rights to be able to use it for marketing material, but I don't have rights to put it on t-shirts that I'm going to sell or other merchandise I'm going to sell. The artist, unless I license those specifically. So this is where minutia comes in about artwork and everything else when you're doing your book is what have I bought the rights to as a part of that asset. So I created it. Do I own it? Is it mine? You own it unless you sold it or leased the rights. You own it unless you contracted with someone to produce the work. For example, a lot of the time I'll get contracted to produce an article about a very specific topic. So if I've done that contract for hire, or I've done that as a part of something, they bought it, they own it, I've written it, I did it as part of contract work. If I have developed that intellectual property as a part of my job, let's say that I'm a copywriter for a company, I don't own that, the company owns those rights. Or let's say that I'm a tech writer for a company, I work for a marketing agency, whatever else. I can do all the creative content in the world, I'm not gonna own any of it, I've done that for my employer.
I have,
Absolutely.
it has to do with the ownership. If someone writes a book, writes something they created, like a book, and you have someone else who says, well, that's really good. A lot of other people would enjoy that. So what they do is they take it electronically and dump it out onto the web in a free zone. Now, I would think they don't have the right to do that because even though they're not collecting any income, they're putting it out as free domain. They didn't necessarily have the right to do that.
And we'll be talking about that, because that's called piracy.
Yeah, even when there's no money involved.
There does not have to be any money involved at all. If you are infringing on the creator's rights, and we'll talk about this, if you have infringed on someone's rights, and that in fact was the next bullet point, you don't own it if your creation infringes on someone else's rights. So we'll come back to your exact case here in a minute. But let's say, for example, in music, there was a famous, there was the infamous, Vanilla Ice story. Did he infringe on Freddie Mercury's song? Or also when we look at when sampling is used in music. And one of the things we're going to talk about here is going to be fair use and when that comes into play. But like I said, if you infringe on someone else's rights in the creation of your work, then no, you don't own that work, or you may not have rights to use that as a part of your new original work.
What about a cover? Bands doing a cover of somebody else's?
Excellent question. A lot of the time when you see people doing covers, now if you're down, you're down at the corner bar and it's the neighborhood band that's just cranking out covers like that, typically no, they are not going to have licensed that music. But there are mechanisms by which theoretically they should be licensing that music. A lot of the time, if they're a band and they have bought the music, they've bought it with a specific license saying we're doing a cover. But a lot of the time, have they done that? No. And this is what gets into that idea of fair use. Is it fair use? Not really. Is anybody going to infringe on that? No. If somebody licenses your work, in other words, they bought the rights to use it, and then they're the ones that violate that license. For example, let's go back to our cover art. Let's say that you are an author and you buy or license a piece of work, or your publisher buys and licenses a piece of work, artwork for the cover or for the marketing and everything else, and then they start selling the t-shirts and they start selling everything else that's outside of the domain of that license. Then that's a violation of rights, and that artist is going to have rights to come back against that. And then last but not least, and we'll have a lot of fun with this, is very loose interpretations of the fair use doctrine can often be a violation that is very much gray area. So fair use doctrine is the grayest area of grayest areas of grayest areas in case law, because nobody can tell you what is fair use. Fair use is pretty much defined by, does the person you borrowed that from, are they going to let you get away with it, whether it's credited or not? So, for example, with fair use, if you are citing something from the media, a news story or something like that, and you're citing that, if you take someone's exact quote and put that into your own work, and you give accreditation back to that source, that's still not necessarily enough to protect you. Now, is somebody going to object? Most of the time, no. With fair use and sampling in music, for example, let's go back to one of the really bad songs from the 80s, and I'm trying to remember what the name of it is, but Leonard Nimoy from Star Trek was sampled and runs in the background of that going Pure Energy.
That would be,
Yeah, yeah. That was sampled in the background.
yeah.
There was a little bit of discussion about that, and ultimately the music company went and just licensed it from Paramount because it wasn't Nimoy that owned it. It was Paramount and Star Trek that owned that sound bite and that sound sample. Would that be fair use? They decided it was easier to go and license it. Currently, I have one of my next publications to come out is a Business 101 for authors. I have throughout that a lot of quotes from different people that sort of set things up. Where I have taken those quotes, I have given the accreditations to the person that has said them. Technically, that's operating under fair use. If I do something along the lines of, I've written a book and I mention something, for example, one of the books I wrote, I make a comment about creating a lightsaber, that the lab, hey, will you make me a lightsaber? That is a protected property of Star Wars. The idea of a lightsaber, the name lightsaber, all that's trademarked and protected, but it's also enough in common vernacular and the common idea and the common culture that theoretically operates under fair use. So fair use, really, we talk about a lot in TVs and movies and things like this. What is fair use? If I show something in the background of a TV for 3 seconds, is that fair use? If they don't sue you, yes. Yeah.
I was thinking about personal images.
Mm-hmm.
There's, Washington and Lincoln sales. They have somebody dressed up like Washington and Lincoln hawking cars or whatever.
Absolutely.
He's a public figure.
He's a public figure.
A dead public figure, but here's theoretically. But if Taylor Swift, somebody dresses up like Taylor Swift and portrays herself as Taylor Swift, I'm certain that
She's going to sue you.
Yeah, because it's not just that she looks like if she was portraying herself as that person.
So let's take the idea of Robot Chicken, because they're obviously known for doing caricatures and public figures and all the rest of this.
Simpsons.
Or The Simpsons. The reason I use Robot Chicken is because typically the actor or the person that is there mimicking, mocking, and everything else is not on the show. Sometimes they are, versus The Simpsons, usually the person being portrayed is on the show. There are a couple of very notable exceptions where one of my favorites was on Futurama, where apparently Larry Bird declined to go on, but he left a voicemail and they used that sound bite and undoubtedly paid some sort of residual and whatnot. But when we talk about fair use, it's all a gray area. And, for lack of a better term, if there is a question or a doubt about using something, call, ask, write, license. Because for the most part, if somebody has something that you want to use or license in the creation of your work, unless it is a major commercial work, most people will either say, here, pay me $100 to license it for that use, or they will just grant you rights.
I got a specific one.
Sure.
My wife wanted to license, she actually wanted to license one of N.C. Escher's prints to recreate in another form.
Okay.
Wrote, never heard back. Now, would that constitute acceptance through admission, or would that be, you didn't get official permission, therefore you're in the wrong?
Well, and this is one of those, it depends on what the intent is to do with the work. So let's say, for example, with that MC Escher work, her intention is to create a three-dimensional diorama. I don't know what her intention is, but let's say she's going to create a 3D-dimensional diorama of one of the pieces of work as a piece of art to then sell. If it is a direct representation of that piece of work, then the short answer is, if it is a one individual unique piece that is not going to be mass produced and mass replicated, you might have one basis on which to say, this is inspired by MC Escher, give the accreditation, but it is a new and innovative work based on the inspiration, and that will be protected. If you're going to mass produce that, that's probably a different question and a different conversation. Again, I'm not an attorney, so again, this is very general, depending on what you want to do and how you want to execute on it.
That would kind of come to that small potatoes category.
Right.
Nobody would care because you're only one person.
Right.
But when you start trying to make money off of it, that's when they're going to nail your ass to the wall.
Most of the time, yes. So let's actually talk about that when you have a violation of rights. Somebody stole your stuff. Now what? And this is what I think is going to bring that conversation about how that action happens. Let's say somebody does come in and steal your work somehow or another. They violated your rights. And I'm going to tell a little personal story here too, as well as some stuff from some clients and friends. Let's say, for example, you find your story that you wrote up on the internet. It's sitting on a pirate site. It's sitting up on somebody's share site, something along those lines. There's a very formal process to go through. The first and easiest thing to do is to drop somebody an email, be polite, and say, hey, this is copyrighted work, you're violating my rights, would you mind taking it down? 99 times out of 100, that will be enough, and you'll get an apology. Hey, I'm sorry, didn't mean to share that out. If that fails, then there is something called the DMCA, the Digital Millennium Copyright Act, and there's a very specific form of complaint that you can go and log. You can go on U.S. Copyright Office and download the form for the DMCA, submit the DMCA, and then if nothing happens, you then can very easily start legal procedures. The DMCA tends to be seen as the first step of a legal action. Normally that will get most people's attention. And I will tell a story about a friend who I will not name, but her husband isn't, or his wife is an attorney. And she frequently goes and says, would you please stop pirating the movies? Because that's on the ISP under my name, and I'm an attorney. But he gets frequent DMCA notices.
He does it and then sells them?
No,
He's just for himself.
He's just copying them for himself. Okay. But even so, if you're in a position where you have downloaded a song, you've downloaded a movie, you've downloaded a TV show that is licensed and owned by someone else, even though that is for his personal consumption, he's still, theoretically, when he watches that, depriving someone of the revenues that would be generated by the act of watching it, whether it was through Netflix, or whether it was going to movies to watch it, whether it was watching it on TV, let's say it was even available on one of the 3 networks, it's still a violation. It's still taking away someone else's rights to earn a living from the work they've created. You will find that there's a lot of legal agencies and whatnot that will go out and have a lot of fun with chasing down violators. And then last but not least, the last thing you can do, you can find your information out there on somebody's website, do a little research, you can notify the ISP, you can wind up shutting down somebody's websites, there's a lot of things that can go out there and happen. 99% of the time you don't have to do that. Now, I'm going to tell a couple of little stories, and this is where the business side of it kicks in. So one of the things that happens, we as creators, we want to spend our time creating, making something new, carrying it to market, and hopefully earning some of our living from those things. Something called the Copyright Alert System, CAS, started monitoring torrenting in 2013. And so the CAS does this automatically, and if there's a violation that they observe, and you have filed your copyright, which is one of the keys there, key triggers, they'll notify you that, hey, your stuff has been found on another torrenting site, and they will typically do things to actively stop pirating. How effective are they? That's a different story and a different question. I don't rely on CAS. The second thing you can use is by creating Yahoo alerts, Google alerts, these sorts of things that look for your name, that look for your titles, that look for specific keywords, character names, things like that. You can use Google alerts, and they'll scan all the the light web site, and they'll tell you where that pops up. Copyscape, Grammarly, a lot of services now do plagiarism checks and will notify you if things are found. I'm going to also tell you that the vast majority of these things that happen, and I'm going to put plagiarism aside for a second, but the majority of piracy that goes on is on dark web, torrenting side, that is not monitored at least by Google or any of the major services because they're not crawled. Now, I'm not going to go into the whole tiers of the dark web and how far you have to go, but think about all the internet that's less than 10% of what exists. The vast majority of what exists on the internet would be in what is quote unquote called the dark web. That doesn't mean it's illegal or illicit. A lot of that's private company networks, that's private entities and whatnot. But there's a lot of it out there that operates under the ideas of what is ultimately criminal enterprise. There's a lot of torrenting that goes on, and a lot of people say, basically protest innocence because, well, I didn't know. I just got it from this website, and how am I supposed to know? Innocence is not a defense, or ignorance is not a defense, I should say. So here's a couple of fun stories. And if you can see this, it's called, if someone is just gonna steal it, I may as well quit. And at least once a month, someone I know, whether somebody I know from conventions, somebody I know online, I talk to a lot of authors, clients, whatnot, back and forth. At least 4 or 5 times a year, I see someone go and stop publishing their work electronically. There's an author I know who over 90% of his income came from ebook sales. Had the 3rd book in a series he refused to allow to be published in ebook because it was being pirated, because the other book was being pirated. And in essence, dedicated a lot of time to making sure that that book wasn't going to be pirated. He's like, nope, if they're not buying it, I don't want to read it. This is a matter of cutting your nose off to spite your face. Another author I know, somebody I know very personally, got involved in a very strong lawsuit and spent a lot of time chasing down, because she had traced at least 13,000 illegal downloads and shares of her book. Spent 3 months chasing that down, and I'll note this is a 99-cent ebook. So the retail cost, let's say it was $13,000, which meant that was about, let's call it, if every one of those people would have bought her book, $4,500. Dedicated 3 months of her life to nothing but trying to chase this down. Did no new work for that period of time, missing deadlines and everything else, for the want of about $4,500. Here's the truth. If you look at violations and you look at what happens, you have a legal obligation to do what you need to do to protect your work and then move on. There's a couple of fun stories, one of which is
You're talking about basically sending a cease and desist letter and
send it back out.
it either works or it doesn't work.
Right. You can send the cease and desist, you can send the nasty grams, you can say, look, take it down or I'm going to take legal action. But if you're down a level where you want to start suing people individually over a 99-cent book, you're not going to win. You are going to ultimately lose. And oh, by the way, let's talk about how piracy can actually work to your advantage. I'm not encouraging it, nor would anybody else encourage it, but there are a couple of very interesting things. If you look at the number of people that will ever see, read, or do anything with stuff they downloaded off of a torrenting site, probably 90% of them never opened that book. So let's say that goes from that 13,000 to 1,300. There's also a lot of statistics that show the people that download a piece of music illegally, that download a book illegally, they take and sample it, figure out if it's something they want or not, and they go and buy it. Now, here's one nice little story that I did a number of years ago, back when it was a lot easier to intercept the files and whatnot with torrenting sites. And I've used this as a marketing tool before as well, where I will take the first couple of chapters, the first third of the book, and then I'll add the link for it here. If you like it so far, go buy it here. If you drop it, here's a sample. You dropped it on the torrenting site, somebody picks it up. You can use these things to your advantage to help build a market.
With your track deal.
Absolutely.
Okay.
I have known there are a number of music artists that successfully use torrenting sites like that to build their entire careers. Because the biggest risk for the vast majority of creators on the planet is not that someone is going to steal and illegally download your song, read your book, or something along those lines, and not pay you for it. The biggest risk is that no one will ever see or hear or know who the hell you are. If you invest more of your time in creating new work, doing positive marketing, and all the rest of that, guess what? More than likely, for those people who find your one book out there that they torrented, that they stole, that whatever else, you have a potential here to build a new reader, to build a new fan for the rest of your work. So while I am in no way, shape, or form encouraging piracy, downloading, illegal action, it's a reality of the business. It's a reality of life. And a lot of the pirating that goes on goes through China, goes through Russia, goes through sites that you can't touch. You can't do anything about it. And you're better off just to keep working and keep producing and put new stuff out there. And there's also a little thing that says if somebody's now gotten to the point where they are ripping off your work and publishing it and putting it out there, then it's free advertising. Now again, you have to take steps to defend it to not lose your potential rights. But again, you have to understand that this is a part of the business. It is a factor of life that if you're in the digital age and you have a digital product, the odds are at some point, if anybody cares, then your work is going to be ripped and pushed out there in some way, shape, or form. Whether that is a song, whether that is a book, whether that is a movie, whatever else, you have to acknowledge and understand that that is a reality. To kind of wrap it up, you know, it's all about, with your IP, if you're creating new work, you're putting new stuff out there, you're putting new stuff together, understand what your legal protections are, know if it's something you need to copyright, trademark, patent, you know, what the legal protections are you need to put around it. Because there are certain kinds of work that may require multiple forms of IP protection. You may have things you need to both copyright and trademark. For example, Harry Potter. The because you have
As a
branding.
fan.
Well, you have branding and execution on that, so you're gonna have both of those protections. And actually, in the Harry Potterverse, they have patented materials with, you know, a lot of the stuff that's out there for sale. They have licensed material out there around the trademark, so if you wanna say, this is the Harry Potter blank, that's a lot of the time, that's just licensed, and your copyright's on the books, movies, the other material, so. I appreciate you guys taking the time.